Your Excellency the Chancellor, Deputy Chancellor, Vice-Chancellor David Turner and Rushia Punjabi, Leader of the Opposition, Attorney-General Sir Anthony and Lady Mason, Sir Lawrence Street, Sir Bruce Williams, Dame Leonie Kramer, members of the Parliaments, former judicial colleagues, and ladies and gentlemen. As has been advertised, this is going to be a conversation, but you don't get your word in until I get mine. Every Sydney graduate, every undergraduate of this university knows this place as a special place. It was here, in this very room and at this podium, that I was welcomed by Sir Charles Bickerton Blackburn back in the year 1956. And it was here, beginning in 1959, that the series of graduations in the Kirby family began. My parents sat just about there at table 25. My father, my late mother, and I came up for my first degree. Every one of us in this hall who was a graduate of Sydney University knows those special occasions. It was here that, as President of the SRC in 1962, I took part with Sir Charles Bickerton Blackburn in welcoming the new undergraduates, just as was done this week by our present Chancellor. And may I say to you, Chancellor, what a much-loved Australian you are, what a wonderful figure you are. And I'm especially proud that tonight I have with me not only my brothers who both came up to receive their degrees, but also my father who celebrated his 93rd birthday last week, and my partner, Johan, with whom I celebrated 40 years of a wonderful partnership and love 2 weeks ago. So we can talk about these things now, and we can be open and honest and candid about them, and that is definitely progress in my lifetime. About 3 weeks or 2 weeks ago, Sir Anthony Mason did me the honour of launching a book which everyone in this room must buy before it is remaindered. It is a magnificent book, if one might say a slightly large book, a collection of analyses by the most learned writers, some of whom are in this hall, of my judicial contributions over the past 34 years. And Sir Anthony, in doing so, in what was, if I can say so, an uncharacteristically uncritical speech of unalloyed praise, at least that's how I saw it and heard it, said that he was declaring there and then that this was the end of the Michael Kirby Festival. Well, alas, Sir Anthony, there have been 4 dinners, 5 lunches, 1 at Parliament House last week, and there are more to come. Though this must surely be, in this great hall, the zenith of my farewells. People are now crossing the road to avoid me, lest they get invited to a function of this kind. And it's therefore a function that we should all seek to enjoy tonight. Now, I owe a great deal to the University of Sydney, and I'm absolutely delighted to hear that the new law school is about to be opened. The Dean of Law, Professor Gillian Triggs, is here, and after we finish here, we won't go in the manner of the 1950s on a moonlight swim, but we'll go on a moonlight walk down the avenue to see the new law school by moonlight, where the future lawyers of Australia are going to be trained. And it was in the law school, in its old decrepit premises in Phillip Street, Sydney, even before the current law school was built, that I first became acquainted with that rather brutal and nasty world of student politics. And it happened, I swear, completely by accident. I was absent from the lecture one day, and Murray Gleeson, who would never tell a lie, said that he nominated me to be the student rep on the Student Law Society in order that they could frighten out of his shyness this quiet little boy who sat in the back of the hall. And so I was elected to the Law Society of Sydney University. I remained very quiet and shy, and I gradually ascended in rank to the secretary and the treasurer and the vice president, but I could go no further because under the arrangements of that time, under the Constitution, the president of the Law Society was a judge of the Supreme Court of New South Wales, and it was Mr. Justice Manning, later Sir Kenneth Manning. And one of the members of the board of the Student Law Society was a very radical student politician, Bronwyn Setright, now Bronwyn Bishop, who was some of you may not believe this, but she was a very radical student politician, and she and Bowden Belinsky, both of them here tonight, urged me on against my better judgment to move vigorously to have an increase in the salaries of article clerks, living from hand to mouth, bread and dripping on £6 a week. The result of which was that the lawyers of Sydney commandeered Justice Manning and said this had to stop. And Justice Manning summoned us up into his chambers in the Supreme Court to put a little pressure on us. I remember sitting down at his desk with him, and he had sandwiches which he dipped in tomato sauce, claiming that this was a habit he had learned, I think, at Sydney Grammar School. Certainly in public education you would have been caned for lesser things. But in the end of it, he said to me, "Now, Kirby, I have to tell you, if you go on with this campaign," and I said, "But it's Bronwyn who's doing this. If you go on with this campaign, I am going to have to resign as the president of the society." My ears pricked up. And I said, "Oh, Judge, this is a terrible blow to us, and we're very sad to accept your resignation." And we immediately repaired, and before he could change his mind, the constitution of the Students' Law Society was changed. The ink was scarcely dry before we had an election. I became the president of the Law Society, and Mr. Justice Jacobs, later Sir Kenneth Jacobs, my predecessor as President of the Court of Appeal, became the patron of the Society, and we went on with our campaign with Bronwyn Bishop at the helm, trying to get value and equality for money for article clerks. And that was what introduced me into student politics. And that led on to my being elected to be the law representative on the SRC, twice the president of the SRC, as Rashir has said, president of the union and fellow of the Senate, elected to represent the undergraduates. I was looking today at the policy speech which I prepared. It looks as though Rashir and I have been looking at the same notes. And in my policy speech, it's really astonishing to see how deep values which are part of your learning and experience at a place like this, they affect you very deeply, and they affect you in a student capacity, but they go on to affect you in your future life. Now, I began I'm a bit apologetic to read this because it's a little bit, it's a little bit political. It says, "If a supine puppet is wanted on the Senate, a compromiser, someone expert at cocktail parties, and always good to second a motion, then out I go. I make no apology. I seek to protect and advance the liberal and tolerant tradition of this university. And looking through it, you know, it's just a wonderful charter. Indeed, it's almost a declaration. It should have been provided to my colleagues in the High Court. It says, what is needed? What is needed, I declared back there in 67. What is needed is a combination of patient persistence in matters of principle and ready compromise and cooperation on matters of form. That was my mandate back in 1967. If you want someone who will restore amity and peace at the expense of the liberal tradition, then you'd better look elsewhere, and I am not your man. If a compromiser is wanted, out I go. If what I have been saying to the Senate for the undergraduates is what they know is right, they will allow me 2 more years to finish the job. And allow me 2 more years they would. In this wonderful declaration of policies and principles, which should be studied by you, Rashir, and by the student politicians of today, I put my whole life and being against retirement. I'm against graceful retirements. Well, I'm still a bit against graceful retirements, and I'm hoping for another function of this kind in years to come. Now, this occasion tonight has been billed as a dinner conversation, and it's no good having a dinner conversation when there's only one conversationalist. And accordingly, I thought that I would use the occasion to expose to you, in the context of 3 cases in the High Court, an important matter which illustrates something that is different from the world and from this university, comparatively different from the university that I found and found me back in 1956 up to my time as president in the 60s. What is really different is the advent of globalism, the advent of internationalism, the growth of international business, economy, and the growth of international law. This is not something that didn't exist before, but exponentially it's increased enormously, increased in importance and influence in business, in science, and also, as I would suggest, in the law. And this is a matter upon which there have been differences of view in the High Court of Australia. And standing here before you now, I want to make it clear that I accept that there are genuine differences of view and that there are legitimate differences of point of view in the debates that have been had in the High Court. If you waited for the Australian media to present these issues to you in a thoughtful and accurate way, then you'd wait an awful long time, I'm afraid, because the media, generally speaking, in our blessed and free country, is interested in infotainment. We travel, all of us, on the infotainment highway, and I'm sure the members of the parliaments who are here tonight would feel the pain of that fact. But there are genuine issues about the use of international law in construing laws of Australia, and in particular in construing the Constitution. And I just want in this conversation to try to provoke some dialogue from you. And because I have to get used to my life after the High Court, a life when solemnity and black robes are thrown aside, the time has come for me to enter into my new life, and this I will now do. This is probably the last time this is going to be dragged out, so feast your eyes on it, because you'll never get another chance. Now, I want to talk about 3 cases, but only briefly, and then to provoke you into questions or comments or criticism. For this is a university, a great university of freedom of expression, and we defend it and defend the right of people to say what they think. The first case illustrates the limits of the use of international law and the principles of human rights expressed in international law. And it's a case called the Minister for Immigration against B. And it was a case concerning some underage migrants who had come to Australia with their parents, and they arrived without visas, and they didn't have the right to come as refugees. They claimed the right to be refugees. Their parents had earlier made that claim and been rejected, but they made their separate claim, and they claimed to be recognised as refugees. The case came before the courts below and the tribunal, and it was all rejected on its road up to the High Court. And their contention was a very simple one, essentially, and it was this. They said Australia has signed the International Convention on the Rights of the Child. It's the most signed international treaty in the world. And the first, the Australian signature to that convention meant that as a nation we had signed on for a provision in that convention which declared that imprisonment of a child, detention of a child, shall be a last resort, a last resort. And the problem was that the Migration Act, in effect and in its terms, required that if the children or if any person came to Australia without a visa, they would have to go into immigration detention. And so that's what happened to the young boys named B. They were put into immigration detention. And they came to the courts, and ultimately the High Court, and they said, you are reading this act too widely. True, it says any person has to go in, but we have signed this convention. It says it's a last resort. Therefore, read the word person down so that it doesn't apply to a child. And that way give a force and effect to the International Convention, but also give force and effect to the general principle of respect, the particular respect and tenderness that the law shows to children. Now that was an argument that would have certain attraction. However, there were 2 problems with that argument, as it seemed to me. The first was the problem that the provisions of the Migration Act contained sections which provided for the searching of children whilst in detention. And that made it clear that Parliament had specifically addressed its attention to the issue of children in detention. And therefore it was very difficult or impossible to read the Act down, given that Parliament had made those specific provisions. And the second difficulty was that the parliamentary records showed that officers of the Attorney-General's Department had turned up at Parliament during the preparation of the bill to be an act and had said, if you pass this bill into law, it will probably mean Australia is in breach of the obligations under the International Convention on the Rights of the Child. But Parliament, knowing that, enacted the law. This was not a matter of different political views. This was a matter which had passed during successive governments. And therefore, because of the terms of the Act, it was impossible for me to read the provision down and say person means adult person, not child. And therefore I had to uphold the claim of the Minister that the Act applied to the children, and so the children were not given relief and were not treated as refugees. Now, I don't know, but I was told recently that those children were last seen being sent, going back into Afghanistan. The reason that the objection was made to their being treated as refugees was that it was contended that they were Pakistanis, not Afghans. But it was reported to me that they were seen going back into Afghanistan. However that may be, the legal question was fairly clear. The second case was a very famous case which in 100 years law students and others will read because of the fact that it dealt with a very hot question for our Constitution and for our laws, which was the subject of a 4-3 division in the High Court of Australia. You don't get a sharper division than 4-3 in the full court of the High Court of Australia because the High Court is made up of 7. And in this case, the case of Mr. Al-Khatib, in this case, the question was whether Mr. Al-Khatib was entitled to be at liberty. And it came about this way. He was born in Kuwait. His father was a Palestinian. His mother was of Jordanian nationality. Neither Palestine would recognise his nationality, but Jordan would not, and Kuwait wouldn't recognise either nationality. Because of the first Iraq war, Al-Khatib's family were thrown into the maelstrom of the anger of the Kuwaiti population. And his father was taken away and he hasn't had contact with him. His mother said to him, I'm going to try to get back into Jordan, but it's very dangerous for you to come with me. And I've heard that Australia is a just country and that you will have a chance if you get to Australia.